civil
notice for
procedure code.
interim relief.
No, it has evolved through practice.
Correct.
Lord, neither in the civil procedure code is there a provision for notice. It has been evolved, Lord, in the last 30, 40 years.
Now it has been
It has happened.
from evolution now reached
It has become
evolution.
It has become a law.
So you first hear a matter 3 days whether your lordship will issue notice, then you hear it for 6 days after you issue notice whether to grant leave,
What?
and then the appeal will ask for 2 hours.
You can correct us from initially it was either granting leave or
Of course,
dismiss.
of course.
I think that's
With
how.
respect, yes, my lord. And then this notice process came because if an interim order is sought, only fair you hear the other side. Otherwise, I remember, in fact, back in the day, the rule, your lordship, but that's why I introduced the rule, saying if there is a counter in the High Court, please file it before us. So we want to know what the other side's case is, and then we decide. So ultimately, what is it? Your
So the
lordship,
entire record is with us, so
entire record is here.
no need to as such.
Exactly. And in a criminal case, where is the counter affidavit?
Lord, that's now the procedure of this court, that your lordship grant, if we go back to the old days, then follow the full practice. That your lordship grant an ad interim order, grant leave. There is no need to hear the other side even for ad interim.
But normally we take into consideration only those documents which were already produced before the High Court.
Agreed, agreed. Things have changed over the years. People give documents across. All this is happening. So if you have a restatement of the law, then we should go back to that position. Where there is no counter affidavit, record of the court, all that is there.
May I have a lord start?
Yeah.
Start to finish 60 minutes. I have a lot for your lordship's assistance. Put my thoughts down in a piece of. Thanks. It's become 5 pages.
Just spacing.
And it looks big because the font is large and the spacing is large.
No, that's okay. That's
It's a relief on the eye.
good for us.
I've covered most of this ground. Section 17 inserted relates to the procedure by which an inquiry or investigation into an offence is conducted. It is a procedural provision which does not carry the obligation or impair any rights of a citizen. Provision would thus be retroactive in the sense it would apply in future in relation to all inquiries and investigations being conducted. Such provisions have loosely been characterized as retrospective. Strictly speaking, provisions that operate in the future but antecedent facts are in that sense not retrospective. In fact, Manoj, this is well settled. If you rely on, if a situation is on antecedent facts, the famous 3-judge bench decision in DCM relied on the English principle of construction, where for the first time company deposit rules were brought in. And the argument was this can't be retrospective, it can only apply to deposits received hereafter. Justice D. Desai in this court took the view that no, it will apply to deposits hereafter, not to deposits received hereafter. So it is not retrospective. Merely because a law for its prospective operation relies on antecedent facts doesn't make it retrospective.
They all come from the colonial sugar.
Colonial sugar. Because the principle, as your lordships know, is this: it is not that an FIR already registered prior to 18 is invalidated. That would be retrospective. But if after today you commence or initiate any inquiry or investigation, this section will apply. So it is not retrospective. It is prospective.
By necessary corollary, probably a next question which would arise according to me, if you say that this is a procedural and would it confer any substantive right on the accused?
The right,
if not followed.
yes, the right. That's a very important.
Then that Garikapati principle.
This court has held sanction provisions, although procedural in nature, are a protection available to the accused and have to be rigorously followed.
In which judgment?
Yes, I'll give those cases. In fact, in Tata, your lordships have allowed appeal saying sanction will not.
If you see in the context of section 19 and 19 4C.
Yes, your lordships have invalidated.
Yes,
set aside convictions.
Yes.
Not in Tata, for example, a serious thing like Tata, one of my lords judges, the lordship has set aside the conviction. Then, and I was wanting to show, I'll be showing that judgment also because it deals with the other aspect. What if there are other offences which are not covered by a provision which requires sanction? Then what your lordships have held is What your lordships have held is that if the other allegations are ancillary in character, then everything goes. And if the allegations are substantive in character, then they may remain, but the data go. So approval, sanction has always been considered, absence of prior sanction has always been considered fatal to the inquiry. And all that is required is you go now, you get the governor's sanction, you register the FIR. It's not that, my lord, the accused gets a discharge or is acquitted or author for acquittal apply, nothing of the sort. It's a safeguard. You haven't crossed this. Up till now, whatever you've done is illegal. You go get the sanction and you register the FIR, and you're back on track. It's not that the offences are eviscerated. So substantive right, not in the sense that you get a go, as they say, get out of jail free pass. That's not what happens. Only this inquiry comes to an end. Para 5 is conducted prior to insertion of the provision, not stand invalidity. That would make it retrospective. In that sense, the provision retrospective. However, all inquiries, it should be in that sense, the provision is not retrospective. I'm sorry, there's a typo there. Lord, please, I'm so sorry. Please add. Provision is not retrospective. However, all inquiries or investigations commenced by a police officer after the insertion of 17A would be governed by the provision. The general principle of the said provision being retroactive can be displaced by express language. So, but these are only general rules of interpretation. Parliament could have limited the application of the provision to inquiries or investigations commenced in relation to offences committed after the insertion of the provision by adding the words hereafter after the words into any offence alleged to have been committed by a public servant. I made this point yesterday, just for convenience. I put all of them down in writing. The legislature was consciously made a provision applicable to a person who is or was employed. The investigation into past offences is clearly visualized by the Act. Words of limitation as set out are conspicuous by their absence. 17AC provides that no inquiry or investigation shall be committed into an offence alleged to have been committed by a public servant without the previous approval, in the case of any other person, of the authority competent to remove him from his office at the time when this was alleged to have been committed. This is intrinsic evidence to suggest that the provision was intended to apply to offences committed in the past without any limitation. The second feature of this provision is that it applies to an inquiry or investigation into an offence alleged to have been committed by a public servant. The focus of the provision is thus affirmed. The person who has it extends to one. I'm sorry, that word is a typo. The focus of this provision thus extends to the person who has committed the offence and not merely the offence. I had made this point yesterday also.